Hi everybody, welcome to Legal Rabbit. I'm Vidushi and I'll be guiding you through your legal studies syllabus. This video is relevant for class 12 students of the ISC Board who have opted for legal studies. I'll be uploading more and more content in this playlist itself. We have online and offline regular batches running for class 11 and 12 legal studies for both ISC and CBSE boards. So for any of you who want to join those batches, there is a number given in the description box. Please get in touch with us on that number and we'll help you out regarding this. So let's get started. The chapter we are discussing is ADR. This is the second class. The first class that I have taken is on judicial and quasi-judicial bodies. So there we have discussed what are judicial bodies, what are quasi-judicial bodies, and what are the differences. Today we'll be discussing the second topic under ADR, which is tribunals as quasi-judicial bodies. Just as a recap, if you remember, I had mentioned to you that the Indian judiciary has a lot of judicial bodies like the Supreme Court, High Court, lower courts, which are the core of the judiciary. So they are the traditional courts, the Supreme Court, High Courts and lower courts, etc. They are all the traditional courts. And apart from this, we have something known as quasi-judicial bodies. Quasi actually means something like. So something that resembles something. In this case, when we say quasi-judicial bodies, we are referring to those bodies which are like judicial bodies. Those bodies which resemble judicial bodies. Okay, so they are not traditional courts, but they resemble courts. Now, as a part of quasi-judicial bodies, we are today going to learn about tribunals, which are one kind of quasi-judicial body. So, by now you know that judicial bodies are different from quasi-judicial bodies in the sense that quasi-judicial bodies are not exactly traditional courts, they resemble traditional courts. And today we are going to study about tribunals, which are quasi-judicial bodies. Tribunals are quasi-judicial adjudicatory bodies. They hear and resolve disputes on a specific subject matter. Okay, let us understand this with an example. For instance, the National Green Tribunal. First of all, it's a tribunal. It's a quasi-judicial body. Secondly, we are saying that it's an adjudicatory body. By adjudicatory body, we mean that it is a body which adjudicates matters, which resolves disputes. A tribunal is an adjudicatory body which resolves disputes just like courts do. Okay, so this is how it resembles a court. Remember, I just told you that quasi-judicial bodies are bodies which are somewhat like courts. They resemble courts. In a simpler way, they resolve matters just like courts do. That's how they perform adjudicatory functions. Thirdly, now this is one thing to note. See, the National Green Tribunal, the example that we were taking, by the name you can understand, it deals with matters on environmental issues, on issues with respect to conservation of forests, conservation of natural resources. So the National Green Tribunal will resolve a dispute only on a specific area. What is that specific area? Here it is environmental issues. Okay, and see, this is how it is also very different from a traditional court, because when you go to a traditional court, then all kinds of matters from civil to criminal to different kinds of matters go to the court. There is no specific area. But when in case of a tribunal, there is a specific subject matter with which each tribunal deals. Now let us see what is the implication here. A tribunal is one, a quasi-judicial body. Two, it is an adjudicatory body because it adjudicates, performs adjudication functions. Thirdly, on what? On a specific subject matter. Next, tribunals are an alternative way to resolve disputes as compared to traditional courts. The topic that we are talking about, our chapter is on what? Alternative dispute resolution. So, alternative dispute resolution means an alternative way, some other way to resolve a dispute. Tribunals are also adjudicating disputes, resolving matters. So, in certain cases, in areas in which we have tribunals, for example, for environmental matters, we have tribunals, for consumer affairs, we have tribunals, for company law related corporate affairs, we have tribunals, okay, for different fields and areas, we have tribunals. So, they are an alternative way to resolve disputes. Let's come to the next point. Tribunals are specialized forums as they only adjudicate legal issues in a particular area for which they have been created and granted power under a statute. Again, if you look at the example I just gave you, NGT, National Green Tribunal, it deals with environmental issues. So, which makes NGT a specialized forum. And where does NGT get the power to adjudicate environmental issues from? See, every tribunal is established under some law. See, if you talk about tribunals, then any tribunal which is established has a corresponding law to it. So, we have something known as the National Green Tribunal Act. This is the statute or law under which the National Green Tribunal has been created, and from where the National Green Tribunal gets the power to act as a specialized forum and resolve disputes related to environmental matters. So, tribunals are therefore what? Tribunals are specialized forums. They adjudicate legal issues only in a particular area for which they have been created and granted power under a statute. Every tribunal is created under a statute or a law. There is a law which authorizes every tribunal. Tribunals provide expert adjudication on specific subject matter as expert members from the relevant field are part of the adjudication panel. Now, one thing you need to know is that in a tribunal, the adjudication panel consists of judicial members as well as expert members. Alright, this is also a difference between a tribunal and a traditional court. In a traditional court, you only have judicial members who adjudicate a dispute, who resolve the dispute. Judges, they are judicial members. In courts, you find judges. So, judges resolve disputes in the capacity of being judicial authorities. But if you talk about the tribunals, then their adjudication panel contains judicial members as well as expert members. Why expert members? Because I just told you that a tribunal is established to resolve disputes on a specific subject matter, remember? So you have to have expert members from that field. If it's the National Green Tribunal, then you have to have experts who understand environmental matters. And that is how a tribunal acts as a specialized forum. These people are members who have relevant knowledge in that field. Tribunals have a limited jurisdiction. Now, if you apply your mind, we have just discussed that every tribunal is established for a specific purpose. So, Consumer Redressal Commission for Consumer Affairs, NGT, National Green Tribunal for Environmental Affairs. We have an Income Tax Appellate Tribunal, which is for income tax related affairs. Different tribunals are for specific purposes. So now, can matters related to contract law come to the National Green Tribunal? No. Only matters related to environmental law can come to the National Green Tribunal. So similarly, for all the tribunals, there are specific fields, which means that their area of operation is limited, which we can say is a limited jurisdiction, limited power. They can't deal with any and every subject matter which comes to them. Alright. Tribunals provide faster adjudication of disputes and efficient disposal of cases within their jurisdiction. One of the main reasons why the tribunal system came in India was that the traditional courts had a lot of workload and pending cases. In order to ensure that the pending cases are lesser in number, the judiciary is not overburdened, and there is faster disposal of cases, we needed an alternative forum. So these quasi judicial bodies, here we are talking about tribunals, are an alternative forum, right? We know that we have a tribunal for environmental matters. So all environmental matters will now not go to the court directly, they will go to the NGT, National Green Tribunal. We know that for tax related matters, we have the Income Tax Appellate Tribunal. So matters will not go to the court, they will go to the Income Tax Appellate Tribunal. So see, the workload on the traditional courts is reducing. And when these cases go to the tribunals, they are having to deal with only those cases. Obviously, they are able to dispose of the cases faster. Tribunals are quasi-judicial bodies and therefore they are not entirely independent wing like the judiciary. See, again, when we mentioned about judicial bodies are part of the judiciary. They are the core of the judiciary. We know the government has three wings: executive, legislature, and judiciary. And the judiciary is completely independent of the executive and the legislature. So, judiciary is an independent wing, which means that judicial bodies are basically independent. The executive or the legislature does not exercise any control on the judiciary, on the judicial body. So, be it the Supreme Court, High Court, lower courts, they are completely independent. But quasi judicial bodies, from the beginning, we are talking about the fact that they are quasi, they are like judicial bodies, they are not completely judicial bodies. Therefore, they are not entirely independent. And tribunals are what? Tribunals are also quasi judicial bodies. So, tribunals are not entirely independent. Now, what do I mean by this? What I mean is that the executive wing of the government does exercise some degree of control over the tribunals. If you talk about traditional courts, if you talk about Supreme Court, High Courts, the judicial bodies, then for them the executive does not have any degree of control. Executive does not exercise any control. But if you talk about tribunals, they are quasi-judicial bodies, somewhat like courts. So yes, in their case, the executive does have some degree of control over the tribunals. For instance, see a tribunal, let us say Consumer Redressal Commission. This Consumer Redressal Commission has independence to what extent? If a dispute, if a consumer matter comes before this court, then obviously in matters of interpreting the law, deciding the case, the Consumer Redressal Commission has full independence. So adjudication related affairs, yes, they can completely independently adjudicate a matter on a consumer dispute which has come to them. But if you were to look at things like appointments in the Consumer Redressal Commission, or if you were to see that what will be the budget allocation, how much budget will be allocated to them, they need some money to function, right? So how much budget will be allocated and how will they be spending that? Okay, if you look at structural aspects, for example, where will the principal bench of the Consumer Redressal Commission be? Where will the other benches of the Consumer Redressal Commission be? In which cities will it be? How will the structure be? So all of these administrative aspects are controlled by the executive. So what are we understanding here? That tribunals are not entirely independent. And in what matters? Mainly in administrative aspects, the executive does control tribunals. So the point that we were discussing, tribunals are quasi-judicial bodies and therefore they are not entirely an independent wing like the judiciary. Tribunals are independent in taking decisions about disputes. However, in matters with respect to administration, the executive wing exercises some degree of control. Let's move to the next point. Tribunals follow simpler and more flexible procedures as compared to traditional courts. Very simply, traditional courts or judicial bodies have more strict set of rules and procedures which they have to follow. Tribunals, being quasi-judicial bodies, similar to courts, not completely courts, so they have that flexibility. They don't have to strictly follow those rules and procedures. Now see, there are two things. One is rules of procedure and evidence, and second is principles of natural justice. If you talk about judicial bodies, which are the traditional courts, Then judicial bodies have to follow rules of procedure, and judicial bodies also have to follow principles of natural justice. But if you talk about tribunals, which are quasi judicial bodies, then they do not have to follow rules of procedures. Whereas for principles of natural justice, yes, quasi judicial bodies, tribunals, have to follow this. So tribunals do not have to follow rules of procedures and evidence, but they have to follow principles of natural justice. Alright, what are principles of natural justice? One principle of natural justice is that both the parties in a case must get a fair chance to present their arguments. They should be heard in a fair manner. Secondly, the person who is judging the case, he or she should be a neutral, unbiased person. There should be no bias, because if there is bias, then there will be unfair judgment. Now, these have to be followed by normal courts also and by tribunals also. But tribunals have a more flexible procedure because they don't have to follow these rules of procedures and evidence which courts have to follow. High courts, supreme courts, lower courts, they have to follow these rules of procedure also, and they have to follow principles of natural justice also. And that is why their processes are more complex and more stringent. Now read here, they are not bound by the rules of evidence and procedure. That is why they have a simpler and more flexible procedure as compared to traditional court. However, they are bound by the principles of natural justice. So natural justice they have to follow, which makes the entire process of adjudicating disputes in a tribunal much more flexible and easy. We discussed how a tribunal is different from a judicial body, but at the same time, when we are saying it's quasi, then we are saying it is somewhat like a judicial body. So then what are the things that make a tribunal resemble a judicial body? Same question can also be phrased as, how does a quasi judicial body resemble a judicial body? Keep it in mind that when we are talking about tribunals, and tribunals are what? Quasi judicial bodies. So first of all, adjudication of disputes. Of course, if a dispute goes to NCLT, National Company Law Tribunal, alright, so any corporate dispute can go to the NCLT, and the NCLT will adjudicate the dispute just like a normal court. So that is how a tribunal is similar to a court. Second, interpretation and application of laws in the relevant field. So a corporate dispute goes to the NCLT. What will the NCLT do? NCLT will see what are the relevant laws. If it's the Companies Act, if it's the Insolvency Bankruptcy Code, whatever. There are a range of acts and laws with respect to company law. So the NCLT will look into those laws, interpret the laws, and apply them in the relevant field. That's how they will pass the judgment. So see, till now they're doing everything that a court does. Adjudicating a dispute, how? By interpreting and applying the law, passing judgments. Issuing orders to enforce the judgment. If the court says that this is right and that is wrong, then the court has to give an order to ensure that the judgment is enforced, that whatever has been said in the judgment is carried out. Enforcing legal rights and obligations. The Consumer Redressal Commission. It is a tribunal. What kind of matters go there? Consumer dispute related matters. Now suppose a consumer A has been charged more than the MRP. So what can the consumer do? The consumer can go to the Consumer Redressal Commission. And the Consumer Redressal Commission will make sure that the rights of the consumer are protected. So what is the Consumer Redressal Commission doing? As a tribunal, it is enforcing your legal rights and making sure that the obligation of the company who is manufacturing the product, say there is a packet of chips which is stale, so it is the obligation of the company who has manufactured to make sure that they check their products. So when the matter will go to the Consumer Redressal Commission, they will pass a judgment in such a way so that they can make the manufacturer fulfill their obligations. They can ask the manufacturer to compensate you for the stale product. The same thing a court also does. When you go to a court for a dispute, it makes sure that your rights are protected, and if there is anybody who is obliged to you, who has to perform that duty towards you, then that person is made to do that, granting relief within their scope of authority. Of course, suppose there is an environmental issue and that issue goes to the National Green Tribunal. There is an issue where a company is said that they are polluting the river because of their industrial wastage. They are polluting many rivers in a city. Now a case is filed against them in the National Green Tribunal. Maybe the NGT, if comes to the conclusion that yes, in fact, the company is polluting the rivers by its industrial discharge, then they can ask the company to compensate for it, maybe by uh, cleaning up the rivers, maybe by doing some water treatment activities. All right. So, any relief which can be granted within their scope of authority. And even the courts do the same thing, right? When a matter goes to a court, then the court gives some kind of relief to an aggrieved party. As far as tribunals are concerned, you must know one thing, that when our constitution was originally drafted, then we did not have anything about tribunals. So, in our original constitution, there was absolutely no provision about tribunals. Later, when the need was felt that we need a set of different bodies who can also handle matters, then the 42nd Amendment Act of 1976 was introduced, and two articles, Article 323A and 323B, these two articles were introduced in the Constitution. Basically, 323A tells you that, okay, Parliament has the power to establish administrative tribunals for the center and the states. Administrative tribunals, you know what they do? See, there are people who are appointed to public services under the government, under the state, under other local authorities. Now, when a person is appointed to a public service and he has some dispute, say I am appointed to a public service and there is a dispute with respect to my service condition, or maybe there is a dispute with respect to my recruitment or my promotion, anything to do with my service condition, then where will I go? For that dispute, I will go to the administrative tribunal. So, for people who are appointed to public services, when there is a dispute related to recruitment and service conditions of these people, then they go to the administrative tribunals. So, Article 323A basically provides for administrative tribunals. And Article 323B is very easy. Any other tribunal other than the administrative tribunals. All the tribunals that we have just spoken about, National Green Tribunal, Consumer Redressal Commission, Income Tax Appellate Tribunal, National Company Law Tribunal, all of these tribunals come in the category of other tribunals. Parliament and the state legislatures both have the power to establish any other tribunal as per the requirement. Now the parliament and the state legislature, they have this power that if they feel they want to constitute a tribunal for a specific purpose, then they can do it. So these are the two constitutional provisions with respect to tribunals. Now your syllabus specifically talks about two kind of tribunals. One is the ITAT, the Income Tax Appellate Tribunal, and one is the NGT, National Green Tribunal. So I'm just giving you a brief idea about these two tribunals. Everything that is true for quasi-judicial bodies is true for tribunals. And all those points you can again write for Income Tax Appellate Tribunal as well. So first of all, Income Tax Appellate Tribunal is what? It's a quasi-judicial body. Okay. So we know what is a quasi-judicial body. It is not a traditional court or a judicial body. However, it resembles a judicial body by performing judicial functions with respect to adjudication of cases on taxation related matters. So we know that how it resembles a judicial body is that any tribunal resolves disputes with respect to specific areas. So disputes with respect to taxation matters can go to the ITAT. It was the first tribunal established in India in 1941 And ITAT adjudicates disputes in taxation matters. Direct taxes. There are two types of taxes, direct and indirect. So direct taxes is what ITAT deals with. For your understanding, if you know that it deals with taxation matters, it's more than enough. It has both judicial and expert members. So for the ITAT again, we have judicial members and expert members. Since it's a tribunal which deals with taxation related matters, so the expert members are generally people from the accounting background. It was established with the aim of reducing the workload of high courts and ensuring speedy resolution and disposal of cases on tax related matters. We had discussed that why were quasi judicial bodies and tribunals established. Tribunals were established because at some point of time we wanted to reduce the workload on the judicial bodies, on the traditional courts. Similarly, before the ITAT was there, these taxation matters would go to the High Court. So now that ITAT is there, it reduces the workload of the High Court. The functions of the ITAT are supervised by the Ministry of Law and Justice. So ITAT basically functions under the Ministry of Law and Justice. If you remember, I had just discussed with you that quasi judicial bodies, tribunals, these are not courts, and therefore, unlike the judiciary, which is a completely independent wing which does not have any control from the executive, the quasi judicial bodies, the tribunals, do have a certain degree of control exercised by the executive wing. See, here is the example for that. The ITAT is functioning under Ministry of Law and Justice. This is what? Part of the executive. So see, you can see how the executive wing does have some degree of control over the tribunals as well. ITAT has appellate jurisdiction in taxation matter. Basically, it means that initially, say if I have not paid my taxes correctly and there is a case against me, first of all, I will go to the income tax authorities. If the income tax authorities give a judgment and I'm not satisfied with it, then I go to the commissioner of income tax. And if I'm not satisfied with the judgment that the commissioner of income tax has also given, then I go to the ITAT. So basically, I am appealing to the ITAT. If there is an income tax related matter, then I directly don't go to the ITAT. It is an appellate jurisdiction. Appellate comes from the word appeal. So the matter goes to the ITAT on appeal. From the income tax authorities, my first appeal is to the Commissioner of Income Tax. From the Commissioner of Income Tax, my second appeal is to the ITAT. That is why we say it is a second appellate forum. I hope this is making sense to you. Orders or decisions of the ITAT are final and binding. So whatever decision the ITAT gives, in my case, if they say that yes, I have not paid my taxes and I have to pay some penalty for that, whatever it is, that decision is final and binding. Okay, but if I want to appeal from the ITAT, then I can go to the High Court. But remember that this appeal from the ITAT to High Court can only happen if there is a substantial question of law that is involved. If there is something with respect to interpretation of law, for example, I feel that no, the decision that the ITAT has given is on an incorrect interpretation of law. The law or the section that has been applied has not been understood correctly, or there is an incorrect section that has been applied. In that case, it's a substantial question of law, so I can appeal to the High Court if I want against the decision of the ITAT. Next on your syllabus talks about the National Green Tribunal. Again, same thing, National Green Tribunal is a quasi-judicial body. It's a specialized tribunal. Specialized tribunal, why? Because it deals in matters with respect to protection of environment, conservation of forests and natural resources. Alright. It was established in 2010 as per the National Green Tribunal Act. So the law that governs the NGT is the National Green Tribunal Act. I had told you in the beginning that every tribunal derives its authority from some law. So NGT derives its authority from the National Green Tribunal Act. This is the act which has established the NGT. And of course, it deals with matters with respect to environmental issues in India, which is why it is a specialized tribunal. It is a specialized forum. Just like any other tribunal, quasi judicial body, it has judicial members and expert members both. Expert members from obviously fields with respect to the environment, people who have knowledge in that field, so that they can be part of the adjudication panel. The NGT currently has 5 benches. That means it is present in 5 places, with the principal bench in Delhi. I would encourage you to find out which are the 5 cities in which NGT is there. Okay. It ensures that environmental rights are enforced and cases related to the environment are resolved expeditiously. Again, we had discussed what does a quasi-judicial body do, what does a tribunal do. Just like normal judicial bodies, like normal courts, they enforce the rights. So here rights would be what kind of rights? Environmental rights, because it's the NGT, it deals with environmental issues. It ensures that environmental rights are enforced and cases related to the environment are resolved in an efficient and fast way. Orders of the NGT are final and binding on the parties. Just as we discussed about the IT-80, remember? Orders of the NGT are also final and binding. But if you feel that you are not satisfied with the judgment of the NGT, what can you do? You can appeal. Where can you appeal? You don't need to go to the High Court. You can straight away go to the Supreme Court. So from NGT, you can straight away go to the Supreme Court. Generally, there is a fixed period of days which are set, and within those number of days, you can appeal to the Supreme Court saying that you are not satisfied with the order of the NGT. Again, this appeal, just like in the IT-80, I told you that there has to be a substantial question of law. Only if you feel that there is something wrong about the application of law, about the interpretation of law, where a substantial question of law is involved, then you go to the Supreme Court and appeal. Otherwise, the order of the NGT is final and binding. So this is all about tribunals as quasi-judicial bodies, the NGT and the IT-80. I hope you have understood all of this. Please write to me in the comment section if you have doubts. Also, we have a Telegram channel by the name of Legal Rabbit. You can come and join us there. For all of you who would like to enroll for our online and offline batches, feel free to get in touch with us on the WhatsApp number. I'll be uploading content on this YouTube channel, so keep a watch and keep following the classes. All the best. Bye-bye.